So the next thing you should look at is your children's inheritance. So a question I get is, how do I leave money to a minor child? I just said that you should not name a minor child as a beneficiary to a life insurance policy. Now, minors can't, as I said, can't own assets in their own name until they become legal adults. What that is will depend on your jurisdiction, as I said. Naming a minor as a beneficiary without also naming a custodian could cause delays in receiving those assets if you were to pass away, right? In your will, you can name a guardian for your minor children. You can also name a property guardian. The legal guardian would be responsible for managing your child's care, while the property guardian would oversee any assets that you left to them. Now, this can be two different people, or it can be the same person. You could then list out the assets that you want your child to receive. If you have multiple children, you can specify what percentage of assets they should receive instead. Just to keep things simple. Let's say if you have 4 kids and you say you want them to receive, your estate, 25% each, and like equal shares, that makes it relatively more simple to administer your assets. So aside from a will, you could also establish a trust, which we talked about earlier. A trust can hold those assets inherited by minor children. You could name a trustee who would oversee those assets according to your wishes on behalf of the children listed as beneficiaries. Now, establishing a trust allows you to leave specific instructions for the child's inheritance. For example, you could state that your child won't receive the bulk of their inheritance until they, for instance, graduate college or reach a certain age, whether it's 25, 30, 35. Another question I get is, should people leave different amounts to their kids? The standard advice among experts is to divide your estate equally between your children. But there are many reasons why parents may choose, another option. There was a Merrill Lynch Bank of America study in which nearly 1 in 4 of the people that they surveyed said that a child who has children of his or her own deserves more money than a child who doesn't have kids. Something to think about. And 2/3 said that a child who steps in as a primary caregiver for an aging mom or dad deserves to inherit more than the other siblings. And 40% of those participants, the participants in that study, with blended families, okay, think Brady Bunch, okay, and I know I'm dating myself with Brady Bunch, but just work with me. Those participants with blended families don't believe that they should treat stepchildren the same as biological or adopted children. Okay, so very, very different opinions. Again, there is no right or wrong answer, but you have to be the one to decide, right? Can one put the legal guardian and the children's name together? And the children. Not exactly sure of the question. Let's see. Can one put the legal guardian and the children's name together? The legal guardian is named, hopefully, Elizabeth, hopefully this answer helps. The legal guardian is named in the will. And if you want the legal guardian to be for a particular child, I'm not sure if that's what you mean, then yes, you can absolutely state that in the will. Great question. Great question.